Thank you for tuning in. It's been a minute since I've made any new videos, and I wanted to share this information with you. Thank you to my subscriber who had brought this to my attention. I know you guys had viewed my other video in regards to contempt of court and about the anti-peonage, and that still does apply, but I want to give you some little bit more information in regards to imprisonment for a debt. Now, first and foremost, I want to thank my subscribers who have donated to my channel, and thank you very much and wholeheartedly. I appreciate you, and it has not gone in vain. So this was took effect of 2002 in the 2002 amendment rather. It's under 28 USC section 2007. It's listed under judiciary and judicial procedures, and it's also known as exceptions and judicial sales. Now this tells you where the money goes when they incarcerate you for alleged debt or any court proceedings that may have been performed. Now, we're going to focus on right now is the imprisonment for a debt. Now, when you're threatened for contempt of court, failure to pay child support, incarceration, I know I hear a lot of people say, oh, the judge did this, but you allow it to happen. You allow them to incarcerate you. And to let you know that the magistrates and the commissioners and the associate judges and friends of the court, they're nothing but they're friends of the court, they're not the court, put you in jail. They're nothing more than a lay person like you and I, attorneys on the bench, if even that. So I want to make it clear that a judge cannot put you in jail for alleged debt. They have to sign a writ of execution, which they do not in child support because it's administrative arm. They also have to have an affidavit to substantiate, and they will not do it. So you guys need to, get them balls out, up from behind you. I'm just kidding. No, but seriously though, they cannot incarcerate you. You allow it to happen because they trip you up. Oh, Your Honor, this, that, this, other. And you do your research before you start going into these courts because, like I said, they know you don't know, and you have to be, equipped what's, really going on. So anyways, so under this section 2007, and let's read here, and I recommend that you get this and keep it as, as your Bible and your, and your reference guide or tool when you're challenging child support, especially under alleged contempt of court. And I wouldn't pay a dime, because when you pay a dime, it's considered you're voluntary making the payment, but of course you can say under duress, fearing of being incarcerated. But I suggest that you get this and read it and memorize it. Anyways, it says, a person shall not be imprisoned for debt on a writ of execution. Now we know, like I said, child support does not do a writ. And even so, when they try to do a warrant for your alleged arrest for a debt, they cannot execute that either, because it has to be signed by a judge and the clerk of the court. And there also has to be an oath or affirmation, and as well as an affidavit to substantiate the alleged warrant. So anyways, let's go on to say, or other process issued from a court of the United States in any state wherein imprisonment for debt has been abolished, which all states it has been abolished. All modifications, conditions, and restrictions upon such imprisonment provided by state law shall apply to any writ of execution or process issued from a court of the United States in accordance with the procedure applicable in such state. Now, this has to do with, I believe, a habeas corpus, because it's going to go to the federal court. Now, any person arrested or imprisoned in any state on a writ of execution or other process issued from any court of the United States in a civil action shall have the same jail privileges and be governed by the same regulations as persons confined in like cases on process issued from the courts of such state. Now, I want to mention under the United States Constitution, Article 1, Clause 3, Section 9 and 10, no bills of attainder shall be passed, or no ex facto law shall be passed. In California, under Article 1, Section 9, it states almost the same as the United States Constitution, and it also states that no I guess it's obliged, paraphrasing, of contracts should be passed as well. So you need to get the Constitution out and read that. And I believe you should incorporate this in your habeas corpus if you're going to do one, especially this imprisonment for a debt. Now, I want to go over to 42 U.S.C. 1994 anti-peonage. And this is in my other video in regards to contempt of court. But I want to reiterate this so that you can have this as your guide. So under Title 42, the Public Health and Welfare, and under Section 1994, peonage abolished, which means slavery abolished. And you hear it as a term of anti-slavery, anti-peonage. And this does apply to you in child support in regards to alleged contracts or debt. You know, the contracts are between you and the child support agency. It's between the state, the county, and the federal government. And basically, you don't owe this alleged debt unless you volunteered and you signed promise to pay X amount of dollars to your ex-spouse. Then you're obligated. So under the anti-peonage, it says a holding of any person to service or labor under the system known as peonage, which is incarceration, is abolished and forever prohibited in any territory or state of the United States in all acts, laws, resolution, orders, regulations, or uses of any territory or state which have heretofore established, maintained, or enforced, or by virtue of which any attempt shall hereafter be made to establish, maintain, or enforce directly or indirectly the voluntary or involuntary service or labor of any person as peons and liquidation of any debt or obligation or otherwise are declared null and void. Make sure you get this information. It's good for you to have. And then also I want to read, let's see, I think I passed it up somewhere. Oh, yeah, right here. So, this is in the United States codes as well. Under name change, or change of name. Now, under the United States magistrate judge, you see how it's lowercase? Lowercase means they have no authority. Magistrate judge and magistrate judge substituted in text for magistrate, which means they have no authority, basically. Wherever appearing pursuant to Section 321 of Public Law 101-650, set out as a note under Section 631 of Title 28, Judiciary and Judicial Procedure, previously magistrate, substituted for commissioner. In California, we call them commissioners, in our state courts, pursuant to Public Law 578, and see Chapter 43 of Title 28. So make sure that you know the difference between a judge and a magistrate. A judge cannot put you in jail, because if they do that, then they're acting as an administrative arm on the executive branch, and their judicial authority is forever lost. Their immunity is lost. So anyways, until next time, you guys, be strong, stay encouraged, and be informed.